Well, let's pick up with holding corrupt judges accountable. And where you stopped off with there, I already got the first part uploaded.
Well, it's not just a simple matter of holding them accountable. There's specific things that we're going to have to do as a collective people in order to get this accomplished. What we have to understand about the Texas Constitution is that it definitely left a lot of power in the hands of we the people. We just have to decide to get together and use it. We can get rid of judges that do this kind of crap. We can get rid of governors and anybody else that does this kind of crap. And we can do it under Article 1, Section 2. Article 1, Section 2 specifically says that all political power is inherent in the people, and that we have at all times the right to reform or abolish our government in whole or in part in any manner that we deem necessary. So that means that we can come up with any number of ways: recall, petition for removal, uh, create an early election process. We have the power under that provision to do whatever we want to get rid of a bad public servant. We just have to band together and do it. We can set our own criteria for how many people are required to do a recall, for instance. We can say it's 5% of signatures in any county. We can say it's 1% if we want to. But we have to at least attempt to get a consensus of the people in order to do that thing, because if we don't, then it can be argued that it's not valid because any one person cannot invoke this protection on behalf of all the other people without their knowledge and consent. See how that works? So we'd have to have, at least to be considered legitimately reasonable, some sort of consensus among at least some number of the population in each county or in the county where that particular public official holds office in order to do something with it. District judges, for example, we would have to seek that remedy through the collective population of the several counties over which that district judge presides. Okay? For instance, as an example. So the higher up we go, the more we need participation across the board from local all the way up to state level by going statewide. All right. So if we're going after a state official, we would need a consensus from the individual counties, or at least the counties that particular representative, for instance, if it's a member of the legislature, that particular representative represents all the people that are in the places where he is their representative. They can petition together to have him removed, et cetera, et cetera. So there's all kinds of ways the Constitution allows the people to take control and get their government back. But then we've got to figure out how to keep it. It doesn't do us any good to replace one corrupt individual with another individual that's exactly like them, and it's only a matter of time before they turn out to do exactly the same thing. This is the problem with the bar associations controlling every branch of government in every state. And if you don't think that's true, then consider how many of the high offices in your state government are occupied by attorneys. Here in Texas, our governor is an attorney. Our Secretary of State is an attorney. Our Lieutenant Governor is an attorney. Our Attorney General is an attorney. Most of our representatives in the legislature are attorneys. Most of our Senate are attorneys. There's not a single high office in the state of Texas that is not occupied by an attorney, with the possible exception of the comptroller, the Secretary of State, and that would almost certainly be about it. And it's possible that either of those two offices are occupied by an attorney. But the simple fact of the matter is that the Bar Association members control every level and branch of our government. Every branch. In fact, they control it so tightly that we, the people, are completely excluded from holding any office in the judicial branch of government at all. We cannot hold any office in the judicial branch that has the power to set public policy and make public record. You get that?
Yeah.
We, the people, have been relegated to the trash heap for positions. We can only hold positions as judges in justice of the peace courts because they're courts of no record and they don't have any real power to do any real thing. And municipal courts of no record because of the same reasons. They have no power to bind anyone to anything other than that particular case. So, because we've been relegated to the lowest power denomination in that department of government, we have been disenfranchised of participation in our judicial department. There's no other way to put it. We have been completely disenfranchised. All because those that hold those offices are bar card carrying attorneys and members of the state and national bars. And that's a problem. Because they're the ones that have come up with the model statute scheme and all these other schemes that are used to create this written law that none of them will follow. They won't follow the Constitution, so what makes you think they're going to follow the laws they enact themselves? No, they're going to hold our feet to the fire to follow it, but it's not going to be used to bind them in any way. Now, we see this all the time. Cops that don't get criminally charged or merely get a slap on the hand for really serious offenses, the rest of us will be serving prison sentences for. Same thing with every other public official. Judges, no matter how corruptly they act, are allowed to retire and keep their pensions and just get out and not have to pay for 1 minute of anything they did wrong unless they're actually caught in serious criminal conduct that can't be ignored because it managed to get outside of the system's control to keep it quiet. If it was found out and discovered by a reporter, for instance, or some member of the public that made it publicly immediately and on a huge scale, they couldn't sweep it under the rug, so they had to deal with it. Otherwise, it's buried and forgotten. The fact that you can't remove a judge without the judges themselves agreeing to it is as reprehensible as I can contemplate. There simply is no public office that should be under review and the control of any other public official. All review should be by the general public. All controls on whether or not they maintain office should be made by the general public. And none of them should be allowed to sit in any panel that is put together by the people to review their behavior and determine whether or not they get to keep their job.
Well, to get back to a couple of your points, to get, 5% of the population of anything would be pretty damn tough. So the next thing is, when they're committing crimes, that's where they are operating out of scope. They don't have, liability at that point when they operate out of scope, so they're committing crime.
You're right. But the question then becomes, who do you have to take that issue to make the determination of the fact that they were operating out of scope?
Another corrupt judge.
Exactly. Someone exactly like them who could be in the same boat and has a political, financial, or personal interest in not finding them guilty.
Well,
And not allowing them to be prosecuted or charged or in any way sanctioned except by the internal process they created to slap themselves on the hand with.
but this gets to where they touch the tar baby and they are shielding
Well, again, the tar baby, you do understand tar can be removed, right?
Well, yeah.
Okay, well, they count on that fact. Touching the tar baby is not automatic destruction of a career. Okay? The question number one is, first and foremost, were they pushed into the tar baby or did they touch it willingly? That's got to be asked, right? It's just like any other type of conduct that a person does by mistake, an honest mistake. They had no idea and did it, and now suddenly there's a problem that they didn't know about it in the first place.
No, because you're giving them a verified criminal complaint against a judge, and they're willfully gonna
Yeah,
try.
but I can falsely accuse somebody of a crime just because I don't like the way they part their hair.
Well,
So the accusation alone is never enough to determine right or wrong. Anybody can accuse anybody of anything. That's exactly why criminal complaints in Texas do not have to be signed under oath. Other than I have reason to believe and do believe. They don't have to be signed under penalty of perjury. They can simply be signed by anybody that believes a crime has been committed. And that's all they have to do is believe a crime has been committed and the person they're accusing is the one that committed it. That's it. That's not fact-based, that's belief-based. But what that does do is create a sequence of events starting with an investigation into whether or not the allegation itself is true.
right.
That's what a criminal complaint is supposed to do, kick off an investigation into the allegation being made. And that's
Uh-huh.
all it's supposed to do. It's not supposed to invest somebody with jurisdiction to prosecute you. Yet that's how they're using it in violation of the Code of Criminal Procedure and the Constitution and all manner of due process. That's how they're using criminal complaints everywhere. Is they're simply treating it as if, okay, well, somebody accused you, therefore you must be guilty, therefore we're going to have a trial and prove it. That's exactly what they're doing in every single Class C fine-only case in the state of Texas. They're not doing the examining trial to determine whether or not there was any probable cause to make an arrest or for the charge to be valid. They're not doing any of that. They're not conducting any investigation leading up to an examining trial. They're simply taking the allegation as true and then prosecuting you for it. End of discussion. That is wrong 9 ways from Sunday. It is also how that 99.6% conviction rate is maintained. By denying the individuals accused in their right of due process. By circumventing all of the specific procedures meant to protect due process.
Well, so now this gets into the book and how it's very well detailed and laid out for them. And I'm going to be submitting that motion based on a chunk of that book and see how they're going to sit here and because they're not going to read it. If they read it, then they have a problem.
Well, if they read it, then that is what you would call touching the tar baby.
Mm,
If they read it and then refuse to apply the law to the facts, now that
right.
they know what the law is and they've seen it with their own eyes, and they know what the facts are, and then they're refusing to take the law as it exists and apply it to the facts as they exist, that's touching the tar baby. And that's doing so knowingly and willfully rather than mistakenly.
What if they say, I'm not going to read that and just dismiss?
Well, then they're denying you in your right of due process by refusing to allow you to be heard.
Yeah.
That's a straight up violation of due process.
Okay.
What good does it do you to go to court to make an argument in your defense when the court says, make any argument you want, I'm going to ignore them and refuse to hear them? How's that not a violation of due process? How's that not a declaration of guilt over innocence? How is that not bias in displaying the fact that no matter what you say, you're guilty? End of discussion. Nothing about that is due process.
Exactly.
So if a judge does that and you followed my rule of document, then it will be readily apparent that judge did so, and you can appeal it on that, and you can potentially sue the judge for acting without proper authority. Because he doesn't have any authority to ignore the law. He doesn't have any authority to misapply the law. None of that is within his jurisdiction to do as a judge. So when he does things that are outside of his jurisdiction as a judge, he does not have immunity to fall back on because he's not acting as a judge. Therefore, no kind of judicial qualified or official immunity can be applied. Because if he's not acting as a judge, he's not acting officially. If he's not acting officially, then there's no qualified immunity or official immunity to invoke. He can't be qualified just because he's a judge. He can only be qualified if he's acting as a judge and his actions are proper as a judge. You follow?
Oh yeah.
So this is where people screw themselves up the most in not following my rule of, number one, everything is to be done in writing. We do it in writing so we make an accurate record. That record is what we use to seek the appeal. It's how we document judicial error, misapplication of law, failure to apply the law to the facts, all the things the judge does wrong or doesn't do that he should have done, or completely did incorrectly. We document all of that so that when we take it to appeal, we can say, look, here's all the way the lower court erred. Here's the way the lower court lost any jurisdiction to try this case, and blah, 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 blah. Thus putting the ball in the court of the appellate court, whatever that court that may be. All right. Now, the thing about the book, as you've mentioned, is this book goes into explicit statutory detail of how the law in Texas actually works when it comes to the transportation code. And the courts and most of the people that go into court to fight their cases, they only read the statute containing the alleged offense. The court and the prosecutor read it so they can understand what the elements of the charge are so that they can properly rule or prosecute the person in the case. And the defendant reads it so they know what the elements are so they can say, okay, all of the elements aren't met, therefore I cannot be guilty of the offense. Because the one thing about a criminal offense and the elements that comprise that offense is that if there are, say, 7 elements, they must assert in the charging instrument, the indictment or the information, all 7 elements. And then at trial, they must offer up proof that each element has been met and proven to be true. If they fail to meet any one of the 7, then they have nothing because the charge is incomplete. The proof of the charge is incomplete. So they can't convict you legitimately with 6 out of 7 elements or 5 out of 7 elements or anything lesser than the full 7. And even then there becomes the question of, does the evidence offered actually support the element they're using it for, etc., etc. But again, those are all things that lawyers pay attention to and try to figure out how to defeat or substantiate depending upon which side they're on. Now, the things you have to understand about regulatory statutes, which is what the Transportation Code is that we have 2 types of law. We have public law and we have private law, which is also known, respectively, public law is also general law, and private law is also known as special law. Regulatory codes, by definition, are special or private law. And the reason for that is because they are intended to impact only a select group of people, a select group of things, and or a select group of activities. Now, it can be all of those things at once, or it can be one of those things at once, or any combination of those things at once. But the thing to take away from it is it's limited in its scope to those specific class or type of persons, things, or activities. Okay? It's not allowed to be applied outside of that scope to anybody, anything, or any act that is not within that scope. And that is what the Transportation Code does and is. Now, every bill in Texas is required to have a caption or a title. And basically all that is a short explanation of what the legislation is at its purpose and what the specific single subject it relates to is. And that specific single subject is both its purpose and its subject matter. And what the legislature is attesting to by putting that single subject in the title is everything in this bill falls within the scope of this single subject. Okay? And for instance, if the single subject was citrus fruits, then everything in that legislation had to deal with citrus fruits, which means it couldn't deal with apples, it couldn't deal with watermelons, it couldn't deal with bananas. It could only deal with fruits that would be classified or of the type of citrus fruits that the legislation talks about. Now, even if the legislation itself only included oranges, tangerines, grapefruits, and lemons as citrus fruits, and it used includes to define citrus fruits instead of the words means, then technically they could encompass things, other kinds of citrus fruit that are not part of that actual list. They're not actually listed there. Okay? But because they still fall within the class of a citrus fruit, by including it, they made that definition expansive. Okay? So when the legislature or the courts or the prosecutors talk about a legislation not being limited because it's defined according to what it includes, they're not saying it's limitless. They're simply saying that it's limited to more than what's listed, but only as long as what's being added falls within the same class or type of what is listed. All right? That's a short, brief, very simplistic explanation of using includes or including to create statutory definitions or to make statutory provisions in law. Okay? And it's very imperative that you understand that, or you won't fully understand a statute when you read it. And I've got 2 articles on my legal blog at tal-of-law.com. I've got articles on my legal blog about the use of includes and including, and you can go search for those and look them up. And there's 2 specific articles, and you need to read them both because they build upon, the second one builds upon the first one. And they'll give you a much clearer, more detailed explanation so you can get a better grasp of this. But in any case, when you go down through this and you find out what's actually being governed by these private regulatory statutes or these special regulatory statutes, you will see that the class of persons, vehicles, and activities are all limited to those that are of a commercial nature. And we can prove that using nothing more than the statutes themselves. Okay? And in Texas, there are 2 codes that we use to do that. The first is the administrative code. The administrative code is necessary because the administrative code is where we catalog and describe the creation and powers granted to state administrative agencies. And here in Texas, the Department of Public Safety, which is our state police force, and the Texas Rangers, which are part of the Department of Public Safety, are actually defined in the administrative code as a state administrative agency. So because they're a state administrative agency, the administrative code necessarily says what their authority is and what they're authorized to do with that authority. And in the administrative code, it specifically says that they are given a specific mission and that the regulatory part of that mission is limited to the regulation of commercial and for-hire traffic. And then it says that in order to perform that mission of regulation, here are the regulatory programs that you can create and administer for those purposes. And the regulatory programs it then lists off are the driver's licensing program, the motor vehicle inspection program, the financial responsibility program, and the safety training of motorcycles and mopeds in the state of Texas. Those are the regulatory programs they're authorized to create and administer. Now, that is where the Department of Public Safety gets its law enforcement powers from. And in this case, it's regulatory powers from. Thus, the Transportation Code is the implementation, the regulations implementing the powers and authorities to create and administer the programs that are given to the various state administrative agencies that are within the Transportation Code, which for our purposes here are the Texas Department of Public Safety, the Texas Department of Motor Vehicles, and the Texas Department of Transportation. Those are the three state administrative agencies whose implementing regulations are codified within the Transportation Code. So as you can see, the Transportation Code is limited to whatever authority is actually granted to each of those state administrative agencies. And as far as regulation is concerned, the Texas Department of Public Safety is limited to the regulation of commercial and for-hire traffic by Rule 1.2 of the Texas Administrative Code. Okay? And this is all under Title 37, by the way, which is specific to the Department of Public Safety. All right? So under Title 37, you'll drill down through all the various sections and chapters and provisions till you find Rule 1.1 and 1.2, and you will see that the mission of the Department of Public Safety when it comes to regulation is the regulation of commercial and for-hire traffic. Now, on top of that, we also have Rule, I believe, 1.4. All right? And Rule 1.4 specifically says, and I'm fixing to find it here. Let's see. Rule 1.3, by the way, lists of specific regulatory programs. That's where I got the list of programs that we're talking about is out of that. And I'm sorry, it's Rule 4.11a. This is Rule 4.11a. And it declares that A, the director of the Texas Department of Public Safety incorporates by reference the Federal Motor Carrier Safety Regulations Title 49 Code of Federal Regulations, and then it lists the various parts of the federal code, the federal regulations that it is implementing in the state of Texas, and then it says including all interpretations thereto, as amended through September 1, 2022. Okay? All other references in this subchapter to the Code of Federal Regulations also refer to amendments and interpretations issued through September 1 of 2022. Now, what this means relative to the Transportation Code is that the statutes within the code must be read and interpreted as provided for by the adopted federal laws. See, when the Texas Department of Public Safety adopted the federal statutes under the Code of Federal Regulations out of Title 49 that it lists here in Rule 4.11a, then it tied everything in the Transportation Code to the same definitions and interpretations of the federal law and must therefore apply those definitions to the state law. Okay? They cannot, regardless of what the Transportation Code does in relation to the state law, it must adhere to an interpretation that is consistent with the adopted federal law that it's being implemented under. Otherwise, the state legislature is attempting to re-legislate an area of law that only Congress has power over in order to expand it beyond its congressional intent. And they can't do that. Whatever Congress enacted, the states are not free to expand upon or to alter in a way the state wants it to work. It is limited to how the Congress enacted it to work. And therein creates a problem of interpretation. The Texas courts keep reading only the Texas law. They go only to the specific statute in the Transportation Code without any consideration for the fact that that statute must be read in accordance with these provisions out of Title 49 of the federal law. And yet we've got it right here in Texas law where they specifically adopted it and must specifically adhere to it in everything they do within the administrative and transportation codes. And yet the Texas courts are failing to apply the federal law in any way, shape, or form. Now remember before, in the first part of this, when we talked about impera materia statutes?
Right.
Well, when the Texas Department of Public Safety, through mandate of the Texas legislature, who wrote the code, the administrative code that this rule is under, when they mandated the Texas Department of Public Safety incorporate the federal law by reference, the federal law became impera materia to the transportation code and everything in it. Now, everything in the transportation code must be read in para materia with whatever exists in the federal law dealing with the same subject. They have no choice. They're just not doing it. Now, we could come up with all kinds of reasons why. They don't know to do it because they don't know about Rule 4.11a. They don't care to do it, which means they're corrupt and not willing to apply the law to the facts or even to look at the law itself to determine what the law actually is. Or it can be any combination of any other corrupt practice and desire you can think of.
Selective prosecution.
Well, it's malicious prosecution. It's not selective, it's straight out malicious. So you can only be selective prosecution if the law did apply, but they only chose a select few to use it against instead of everybody that it applied to. That's selective prosecution.
Okay.
When they're prosecuting you under a law that has nothing to do with you, and they have every capability of knowing and understanding it had nothing to do with you, that makes it malicious prosecution. They attempted to charge you with an offense they knew or should have known it was impossible for you to have committed.
That's right.
Okay? That's the distinction between the two. Now, given that, we have the courts that are refusing to look at the law. Then we have courts that, because they haven't looked at the law, are refusing to properly apply the law. Thus, that 99.6 conviction rate is maintained by people getting falsely and maliciously prosecuted and found guilty in courts that refuse to know and apply the law properly. So when we say the system is corrupt, that's not just a general belief. It's demonstrably provable that it is absolutely corrupt. And I just did it. I just showed you that if you go and read these particular pieces of legislation, and then you look at what's actually happening in the courts and how they're doing it, they are 100% corrupt. But then again, so are the prosecutors, so are the defense attorneys, and so are the cops who are charging you with offenses that don't have a damn thing to do with you. They're all corrupt, and it could be either out of ignorance or because it's a willful ignorance. And which one is worse? Accidental ignorance or willful ignorance? Well, I'm going with willful ignorance.
Yeah.
Because they choose to remain ignorant so they can claim ignorance when they misapply the law and prosecute you with ill intent, knowing they had no right to do it, but they did it anyway because it is how they get their money. Taxation by citation. Okay?
Yeah.
This is how they do it. Now, that's just one part of proving how they're misapplying the law. This book and all the stuff I'm going through in it dissects every part of it step by step, all the way down to the actual police officer making the charge in the first place. And right now, let's see, I don't even know how many pages long this book is at the moment. It's 93 pages long so far, and there's going to be a whole lot more to go into it by the time I break down all the various things I've discovered over the years. but I'm trying to do it in a very organized and digestible manner so that you can read it. It's easy to understand, and it's not a problem. And hopefully, Scott, after you got the cleaned up version and read through it, you found that that was the case.
Yeah.
But the goal here is to educate the public and achieve something that the system right now knows we can't. And that is eliminating their power, first and foremost, through something we absolutely can do and can control without any of them being able to stop it. And that is the use of jury nullification. If you know the information that's in this book, and you get selected to sit on a jury in a traffic case, you can look at what the state is accusing the person of, and then look at the fact that, one, they never ever mention the primary element necessary to make the allegation in the first place, which is that the person they're charging with a transportation offense, whether or not they were ever actually engaged in transportation when they got charged. They never assert that element. They never prove that element. And believe me, it is an element, because I've got an illustration in here that shows you how this has to work in order for them to do it properly. The legislation is required by the Texas Constitution to identify the single subject it applies to. In the case of the Transportation Code, that subject is transportation. Now, the federal law specifically defines what transportation or transport actually is. And it specifically says that transportation or transport only applies to people that are engaged in commerce. So that those two links in the chain are joined together and inseparable under the federal law. And because the state of Texas adopted by inference that same federal law, they now take the interpretation of federal law contained in the federal statutes and must apply it to the meaning governing the Transportation Code in the state of Texas. Transportation means the same in Texas as it does under the federal law they adopted. Commerce. No ifs, no ands, no buts. Yet they never allege that the person was engaged in commerce when they committed the offense. And the problem is that offense is subject to the determination of whether or not the person was so engaged. If the person wasn't engaged in commerce, they could not have committed the offense. End of discussion. Because in order to be charged with a transportation offense, you must first be engaged in transportation in order to commit it. You would think that would be logically coherent to these people, but it's not. They act like transportation is not even a consideration. In fact, the Third Court of Appeals here in Texas ruled in a case called Perkins v. State that that's exactly the case, that transportation is not even considered. Okay? This is what they wrote in the opinion, Perkins v. State, Texas Court of Appeals, 3rd District, in 2016. The definition of transportation is irrelevant to the offense for which Perkins was charged. A person commits the of fleeing or attempting to elude a police officer if the person operates a motor vehicle and fails or refuses to bring the vehicle to a stop, or flees or attempts to elude a pursuing police vehicle when given a visual or audible signal to bring the vehicle to a stop. Well, here's the problem. The offense itself is codified under the Transportation Code in 545.421. And the meaning of and the definition of transportation is codified in the federal statutes under Title 49 and governs the meaning of transportation as it pertains to Texas law. So you cannot read the offense in a way that divides it and separates it from the context of transportation. Because if you do that, then you're violating not only the way the law is structured, but you're violating the single subject clause of the state constitution. Because what you've done by separating the offense from the single subject of transportation is you've converted the offense into its own standalone subject. Thus, you have now made a piece of legislation through judicial fiat that contains multiple subjects in violation of the single subject clause. You can't do that. But you also cannot logically separate the two because the offense depends upon and relies upon the existence of transportation in order to even be an offense. So this was flat out wrong. But the court went on to show its stupidity. It then says, see Texas Transportation Code 545.421A, and then it argues that the word transportation is not used in the statute. No, it's not expressly stated in the words of the statute, but it is inherent in the fact that it is the single subject within which the statute exists. But the court continues, nor is being engaged in some activity deemed to be transportation an element of the offense. Dead frickin' wrong. It is the threshold element of the offense, because you can't commit the offense without the existence of the transportation itself. It is the threshold element. Therefore, it's the primary element. Without that one single primary element, you can never get to any other element within the offense itself. Period. Relying on his own definition of transportation, Perkins argues that the Toyota Prius he was driving could not be a vehicle under the Texas Transportation Code since there was no transportation involved, and therefore he could not have been found to be operating a motor vehicle. We have previously rejected the arguments Perkins repeats here to support his definition of transportation, which they did in the 2015 case against the same guy. They rejected it all out of hand, just like they're doing here. And in both cases, they got it completely wrong by making the same argument, that transportation had nothing to do with it, when it has absolutely everything to do with it. So, let's talk about my analysis of this piece of this case. This is the problem with allowing narcissistic elitist individuals to acquire the power of our public offices and abuse that power to their own ends or through sheer incompetence. Many judges very incorrectly think that they are not only never wrong, but are the sole arbiter of what the law says and means because no one but them is actually intelligent, qualified, and capable enough to possibly comprehend something as nuanced as the law in order to properly read and understand a statute. However, despite having almost no formal education of any kind outside of just reading books, Abraham Lincoln became not only a capable and well-respected lawyer, but also the 16th President of the United States. So as Mark Twain said, don't ever let your schooling interfere with your education. Remember, judges are just attorneys with way more power to do good or ill and a better sounding title. A title that does nothing to make them more intelligent, competent, or better human beings, either morally or ethically. And then I go into an explanation of Kamala Harris and how she's had all these important job titles and still completely sucks at everything she does. Okay? But that's not the important part of this. The important part is what comes after that paragraph. And that is, transportation must be alleged and proven as threshold element. Okay? The Texas Transportation Code contains a statutory section dealing with the objective of first sale. Pursuant 501.002 subitem 8 Transportation Code, first sale is defined as follows. And I go through an explanation of how a first sale is done and blah, blah, blah. And that leads us up to a discussion of how the rest of this works. Because this first sale thing they do is another example of how they're misreading and misapplying the statutes to specific actions. This is but one of the numerous examples within the Transportation Code that prove precisely why transportation must be both stated and asserted and proven, as a threshold element of any Transportation Code related criminal allegation. And so we go into a more legal and statutory analogy. The threshold penal element works, that goes into explaining it by comparing it to the failure ID statute. Let me get into where I did this. Okay. Transportation is defined by Texas state statutes. There is not a single statute in the entire collection of Texas's expansive statutory enactments that defines the singular term transportation, despite the fact that transportation is the specific single subject matter governing the contents, reading, interpretation, and application of the entirety of the Transportation Code. In just a short while, you will learn exactly why I believe that is, and exactly why I believe that the knowing and willful omission of a state statutory definition was an intentional act of blatant and malicious fraud upon the general public by the Texas legislature, whether it was perpetrated through apathy, ignorance, or outright corruption. If you don't wish to take me at my word that the Texas law does not define the singular term, I provided links to the search on how to find it and determined that it just isn't there. So then I break down how transportation is defined according, first, by federal statute. The terms transportation and transport are conjoined and defined within the relative federal statute of 49 CFR 171.8 as the movement of property and loading, unloading, or storage incidental to that movement. Regulatory purposes of 49 U.S.C. Section 113. As the United States Code contains the actual legislation enacted by Congress, which is the legal foundational source of the implementing regulations within the Code of Federal Regulations, the CFR. And remember, people, that's the difference between the USC and the CFR. The USC is the actual law enacted by Congress. The CFR is the Code of Federal Regulations, where the administrative agencies responsible for implementing the federal law enacted by Congress in the USC writes the rules and regulations governing how to bring the legislation to life and administer it and enforce it. That's the difference. Well, here in Texas, the administrative code is the USC, and the transportation code is the equivalent of the CFR. Okay? The transportation code is the implementing regulations of the legislation created in the administrative code governing the state administrative agencies, in this case specifically the Texas Department of Public Safety. Okay? Therefore, we must begin by reading 49 U.S.C. 113, wherein we can see that its legislative purpose is as follows. Public law, the purpose of this act, and then it says see tables for classification R, to improve the administration of the Federal Motor Carrier Safety Program and to establish a Federal Motor Carrier Safety Administration in the Department of Transportation. And 2, to reduce the number and severity of large truck-involved crashes through more commercial motor vehicle and operator inspections and motor carrier compliance reviews, stronger enforcement measures against violators, expedited completion of rulemaking proceedings, scientifically sound research, and effective commercial driver's license and testing, record keeping, and sanctions. Okay? That's the purpose of the law enacted by Congress. Okay? And then put forth in the Code of Federal Regulations as the various regulations. So this is what Congress enacted, and then when we get to the CFR, we're going to see how it's being implemented. So what does this actually mean? It means that 49 CFR contains the implementing regulations that were needed to fully facilitate the mandates of 49 U.S.C. Section 113, i.e. the Federal Motor Carrier Safety Program and the creation of the Federal Motor Carrier Safety Administration, the federal administrative agency created to oversee and manage the program. What it also tells us is that the act is regulatory in nature and has a limited application. Specifically, it regulates only commercial motor vehicles and those persons who serve as drivers or operators of those types of vehicles operating in either interstate commerce or interstate commerce upon the highways. This all becomes more important and detailed later, so pay attention. And again, if you're not getting it with me just talking about it, it would be easier to get if you actually just bought and read the book, which will be part of the new seminar material when I get it all finished. Transportation is defined by the United States Supreme Court. Within the overall context of Title 49 CFR and the federal statutory definition of transportation or transport as provided within various parts thereof, in addition to 49 CFR 171.8, the United States Supreme Court determined transportation or transport to more accurately mean the movement of goods or persons from one place to another by a carrier, and they decided this in the case of Interstate Commerce Commission versus Brimson. Although Brimson dealt primarily with railroads serving as ground transportation carriers, most likely due to the year in which it was decided, which was 1894, the case should be no less applicable to other kinds of well-known ground transportation motor carriers in use today. Furthermore, the federal statute expressly combines both transportation and transport within the same definition. Thus, it is a reasonable conclusion that this was intentionally done by Congress so as to ensure that no interpretive distinction could be reasonably made between the two terms. Therefore, it is equally reasonable to assert that for all intents and purposes relating to transportation, both terms are interchangeable and mean exactly the same thing. Summary. This section provided authoritative sources showing how the state of Texas statutes, the federal regulations within Title 49 CFR, and the statutes within 49 U.S.C. Section 113, as well as the United States Supreme Court, all define the terms transportation or transport. In so doing, the conclusion that these terms relate only to a specific statutory class or category of regulated persons, i.e. carriers, or more specifically motor carriers, as being the only class of persons involved. The information in this section lays the beginnings of the foundation needed to prove that the terms transportation or transport apply only to those persons who serve as drivers or operators of commercial motor vehicles involved in intrastate commerce or interstate commerce. And more will be shown on this specifically. And then we go into what I discussed before about the stated mission of the DPS. Whereas we go to Rule 1.2, and the mission of the Texas Department of Public Safety is, and it goes through items 1, 2, 3, 4, and 5. The pertinent parts here being that when it comes to regulation, there are only 3 provisions here that deal with regulation. 1A2, 1A4, and 1A5. Okay? 1A2 to supervise and regulate commercial and for-hire traffic, which is exactly what I told you earlier. Rule 1.24 is to administer regulatory programs in driver's licensing, motor vehicle inspection, and safety responsibility, which is insurance. Okay? And again, regulatory programs relative to the regulation of commercial and for-hire traffic, which is what they're regulating. Okay? And these are the programs meant to perform that regulation. And then 5, to execute these regulatory programs, supplementing and supporting the preceding activities. Well, the programs they must execute, if they're regulatory in nature, then they only apply to these programs. They must be involved with these programs, and these programs only regulate commercial and for-hire traffic. They've laid it out for you right in front of you. And this is something the courts completely either haven't read or completely ignore. Okay? Now, that covers the entire mission of the Department of Public Safety. Regulatory authority granted to the DPS. As you can see from the above Rule 1.2 Texas Administrative Code, the Texas DPS is only authorized to regulate those persons and devices that constitute commercial and for-hire traffic, which fundamentally limits their ability to regulate persons, vehicles, and activities to only those who are actively engaged or are being used in some transportation-related business occupation or profession as part of that same commercial and for-hire traffic. So get that? Transportation is the equivalent of commercial and for-hire traffic, which is itself the equivalent of commerce. Okay?
Well, that's where that appeals court judge got screwed right there. It says it clearly.
Yep. The important point being that there is nowhere else within the administrative or transportation codes that expand the regulatory authority of the Texas DPS, and by extension that of any local law enforcement agency or officer, beyond that of commercial and for-hire traffic. And to unlawfully use the regulatory statutes of the Transportation Code against persons and automobiles that are not so engaged is blatant fraud and an abuse of regulatory authority against the people of Texas, which constitutes acts of official oppression and abuse of official capacity, which are crimes, all of which are actual jailable offenses and civil torts in and of themselves. Again, a summary for this section. The Texas DPS has a known legal duty to properly understand and apply the regulatory laws the agency is empowered to administer. And part of that duty is to properly inform the public of how and when those laws apply, as well as when they don't. The Texas DPS has utterly failed in the performance of that duty, opting instead to use those laws to mislead and defraud the public by remaining silent as to the law's actual, inherently limited regulatory purpose, the regulation of commercial and for-hire traffic only, and not the traveling public. Even when confronted with the law and the facts, the leadership within the Texas DPS knowingly and willfully refuses to properly interpret and apply the laws they administer. It is this knowing and willful criminal misconduct in interpreting and applying the laws that makes the Texas DPS a criminal enterprise and its director the criminal ringleader. Now we get into the regulatory programs the DPS is authorized to create and administer. And you remember, I read you the list. It's right there in Rule 1.2, Subitem 5, that tells you what they are, or I'm sorry, Subitem 4, that tells you what those programs are, and the fact that 5 limits the implementation of those programs to the preceding mission duties prescribed. So now let's talk about those programs individually. Texas DPS regulatory programs apply only to commercial and for-hire traffic. Texas DPS regulatory program driver licensing. Texas Transportation Code Chapters 521 and 522 codify the specific implementing regulations for the driver licensing program the Texas DPS is mandated to establish and administer under the provisions of Texas Administrative Code Rule 1.3 B2A through C. Texas DPS Regulatory Program Motor Vehicle Inspection. Texas Transportation Code Chapter 548 codifies the specific implementing regulations for the Commercial Motor Vehicle Inspection Program the Texas DPS is mandated to establish and administer under the provisions of Texas Administrative Code Rule 1.3 B2A through C. Texas DPS Regulatory Program Motor Vehicle Safety Responsibility, meaning insurance. The Texas Transportation Code Chapter 601 codifies the specific implementing regulations for the Safety Responsibility Program the Texas DPS is mandated to establish and administer under the provisions of Texas Administrative Code Rule 1.3b2a through C. Texas DPS regulatory programs have strictly limited application. Remember that Texas Administrative Code Rule 1.2 Subitem 5 specifically identifies and declares that the Texas DPS is expressly authorized only to execute programs supplementing and supporting the preceding activities, which Rule 1.2 clearly states is expressly limited to the regulation of commercial and for-hire traffic when it comes to any transportation-related regulatory programs and enforcement actions. Rule 1.2 Subitem 4 expressly limits all regulation by clearly stating that such regulation is to be performed through these specifically identified regulatory programs. And those programs are applicable to and enforceable upon only those who are participating and using the public right-of-way as part of the commercial and for-hire traffic thereon. Remember also that the single subject stated within the title of SB 971, 74th Legislature of 1995, page 2085 of 4210, on line 3, relating to transportation, which is commerce, applies only to those legal capacity persons who are actively part of the commercial and for-hire traffic and using the public right-of-way as a place of business for private profit or gain, rather than the traveling public who are using it as a matter of right in their personal and private capacity. Thus, each of the above listed regulatory programs is statutorily limited in their individual and collective application to only those persons, devices, objects, and objectives that are actively participating in transportation as part of the commercial and for-hire traffic that is using the public right-of-way as a place of business for the purpose of generating private profit or gain, i.e., again, commerce. Anything relating to a motor vehicle is bound to commerce, and I go through everything about this. Now we're going to delve into the federal law and compare it to the state law and see how the state law is directly tied to the federal law. Remember that the Transportation Code is based upon adopted and integrated federal law specifically pursuant to Texas Administrative Code Rule 4.11a, which declares again The director of the Texas Department of Public Safety incorporates by reference the Federal Motor Carrier Safety Regulations under Title 49 Code of Federal Regulations, all these individual parts as amended through September 1 of 2022, including all interpretations thereto. All interpretations. Interpretations apply not only to the way the statute reads, but also to how terms defined by the statute reads. Keep that in mind. Everything's affected. Okay? What this means relative to the Transportation Code is that the statutes within the code must be read and interpreted as provided for by the adopted federal laws, which now supersede any other reading and interpretation of any provision of the Transportation Code that relates to anything contained within the adopted federal statutory provisions for purposes of regulation. And the federal regulations clearly and expressly state that their regulatory purpose is strictly limited to those actively engaged in transportation and using the public right-of-way as a place of business for private profit or gain, i.e. commerce. Therefore, it is neither impossible nor improbable, and is in fact almost a 100% certainty, that not even the corrupt Texas courts can continue to interpret the provisions of the Transportation Code as applying to anyone or anything other than those persons and devices that are part of the commercial and for-hire traffic that is actively using the public right-of-way as a place of business for private profit or gain by actively engaging in transportation, i.e. commerce. Therefore, since the single subject governing the Transportation Code is and remains the subject of transportation, the requirement to both register a motor vehicle and to obtain a certificate of title for said motor vehicle or anything else relating to a motor vehicle are equally limited to only those motor vehicles that are actively engaged in commerce. Okay, let me edit this here real quick so I've got that in there.
Editing the book in real time.
Yeah.
Well, the thing is, for everybody listening, this applies to every state. Every state adopted the Code of Federal.
Whoa. Do not say that. Until you find the actual statute that says that, you cannot say that. It is more than likely that this is what every state has done, but you still must locate the legislation that did it in order to actually prove it. Otherwise, it's just speculation, and it's inadmissible as speculation. The legislation is admissible as public record and as the law of the state. Find the legislation, then you can make that statement as far as the state you found it in is concerned, but not before.
Okay, I stand corrected.
Okay? Do not make that presumption. Presumptions kill in a court of law. Okay, anyway, they're all limited to commerce. Now, going back to the example up there of the first sale and the certificate of title, which is why I discussed it in the first place. Let's use the motor vehicle certificate of title as an example. The motor vehicle certificate of title is directly bound to commerce. Texas Transportation Code Chapter 501 codifies the specific implementing regulations for certificates of title. Within Chapter 501 Transportation Code, commonly referred to as the Certificate of Title Act, Section 501.002 Subitem 5 alternatively defines department as the Texas Department of Motor Vehicles. Remember what I told you about there being multiple state administrative agencies within the Transportation Code. Department of Motor Vehicles, Texas Department of Public Safety, and the Texas Department of Transportation. Those are the administrative agencies that have regulatory authority within specific provisions and chapters and titles of the Transportation Code. It is their implementing regulations for the authority granted to them. We will get into much more detail about the adopted federal law shortly, but for now, you just need to know that the relevant federal statutes are applicable to all employers, employees, and commercial motor vehicles that transport property or passengers in interstate commerce. Again, this is taken directly out of the USC provision we read earlier. Thus, the federal statutes also limit the requirement for registration and the subsequent obtaining of a certificate of title to only those same employers, employees, and commercial motor vehicles that transport property or passengers in interstate commerce. See, you can't separate the two. You can't say the state law applies above and beyond what the federal law applies to when you specifically adopted the federal law, and the federal law limited its application to only those transporting property or passengers in interstate commerce. The state is not free to expand it beyond that. This is the rock and a hard place they are about to run into, provided you take this information and you write a proper legal argument that forces them to hit it. And that's what this book and all the related documents and pleadings I'm writing are intended to do.
Well, how soon do you think you're going to have that book and ready to start on the seminars?
Well, people have been asking me that since the first version was put out in 2008. Does that answer your question?
That's a long time ago.
That was a long time ago. But having to continue on with the research and the radio show and talking about all the other things that I deal with, such as violations of the Code of Criminal Procedure and property taxes and all this other stuff that I delve into, my focus has not been able to be fixated on the transportation stuff. Now that I'm here in Plano and I haven't been able to do the radio show except intermittently for the past 3 years I've been here, I've had a lot more time to focus on getting this done, especially since I got injured in June and haven't even been able to work doing the dog training and everything that I've been doing while I've been living here. That's how I make the money to pay the bills and everything else. And since June, I've had very little of that because I injured both my knees, broke some ribs, injured my shoulder, my wrist, and my elbow on a broken sidewalk here in my neighborhood by tripping over it in the middle of the night while I was walking my dog. I didn't know this piece of sidewalk was in the condition it was in, and tripped over it and hit the curb on my ribs and my knees and my shoulder. And if it hadn't been for my arm falling the way it did and my head hitting that, I would have completely bashed out my brains on the curbstone as well before falling out in the middle of the street. So it was quite an ordeal. And so I've been recovering from that. And while I've been sitting here doing that and going to physical therapy for it, I've had all this time to sit down and just completely focus on writing this book. So the 90 some odd pages I've got in it right now have only been here since, well, when did you get that first version of it from Randy?
Oh, that was
About 2 or 3 weeks ago?
no, that was actually we did that little seminar over at the Sky Pony February, I think.
I didn't have this done, I don't think, in
Maybe
February.
March.
It had to have been sometime this month, which means it was 2 to 3 weeks ago.
Oh, I guess it was.
Okay?
Whenever it was when I saw it, and
Yeah,
then
that's when I gave Randy the first version of it to look at.
yeah,
And he liked it so much, he just adopted it entirely as it was written on that day.
oh
And
yeah,
it's,
it's good.
yeah, it was only 40 something pages on that day, and it wasn't as fleshed out. It just went through the specific steps of joining the statutes together. It didn't
Right.
go into a lot of extra explanation and comparison like the version of it does now, but I've still tried to maintain the focus. I've just tried to expand the technical side of it to give more clear explanation and comparison examples so that those with less of a legal and statutory reading education can understand it as well. I've tried to make this where it's understandable by whatever common denominator of person gets their hands on it to read it. And sometimes that means being more verbose than I would like in order to make it as foolproof as possible, because I have learned over the years there is no such thing as foolproof. You can give something as clear as a pane of perfect glass to an individual, and that individual can still find a foolish way to screw it up.
Yeah.
Okay? And so there is no such thing as foolproof. So all I shoot for is to get it as close to being foolproof as one could possibly get, at least within reason. If you are so objectively ignorant and incapable of understanding so as to be called a fool in relation to reading this, then there's nothing I can do to help you, and I can't lower the IQ points in reading it any further to make it available to you. That's just going to be the way it is. Uh, so that said, I'm not trying to insult anybody directly. Just understand that if you can read this 1,000 times and get nothing out of it, there's probably a reason for that, and it's no fault of mine. Um, so
Well, you don't have a Rumble channel yet, so you need to get. I know.
I actually am on Rumble. You're right. I don't have anything set up on Rumble. I do have a YouTube channel, which is at Tao of Law, on all one word, TAOOFLAW. I've got a YouTube channel up with some of the videos that I've done on past interviews and things like that. I've got like 29 or 30 videos up there right now. When I get this book done, I might break this book up into sectional videos and make it a video course, not just a reading course.
That might not be a bad idea at all because a lot of people listen. You got truck drivers that listen while they're just going down the road. They like it. They don't have to sit here and stare at a screen. They can just listen. A
Yeah.
lot of people do that, you know.
Yeah, and some people actually learn better audibly than they do visually, and so I don't have a problem with that. It's just I'm not sure my voice is the one they want to listen to for hours on end to do this. So we'd have to find somebody to narrate it by reading the book and making the voiceover for it at the very least. And in that case, they wouldn't even have to understand it. They just
Yeah,
have to read
right.
it. Okay.
Well, we need to do this more often. So maybe next week, or let's put this video out and see how it goes with everybody. And if they want more, put in the comments you want to hear more from Eddie, and we'll just keep beating this dead horse until it finally, catches on.
Well, the problem is it's not a dead horse. It's simply a well beaten and bruised horse that the courts have done their best to kill.
Yeah.
But so far, with people like me doing the research and knowing that what they're doing is fraud, it's not dead yet. And
Right.
that's their greatest fear, is that it's not ever going to die and they're going to be forced to finally admit that they've been doing it wrong. There is no greater way to get on the bad side of an attorney than to prove him wrong and you not be an attorney.
Yeah. Oh, I sent you an email. I was talking to an attorney guy. He's at the gym,
Yeah.
and we were going back and forth.
Yeah,
I
and
was saying,
immediately he brought up the right to travel argument, which I didn't see you mention at all.
at all.
He just took what you said and equivocated it to a right to travel argument and said
Mhm.
they've all lost on
Oh
it,
yeah.
and called them sovereign citizens to boot.
Oh yeah. Well, I wrote him back and I said, well, the SCOTUS has upheld the right to travel in many arguments in the past, and there's no such thing as a sovereign citizen. You're one or the other.
Yeah. But that said, I
But then
do
I
teach.
also wait. I did have to follow up with. Isn't it funny how they want to label us a sovereign citizen, but if you file a suit or a tort against a public official, they want to claim sovereign immunity. Isn't
Yeah,
that something?
exactly. But all that said, I do teach legal self help classes online over Zoom. And if you want to participate in those classes and join up, they are by subscription only. However, the first class of each month, and it's on Thursday. Right now, it's at 7 p.m. to 9 p.m., but it's about to switch to the summer schedule, which will be from 8 to 10 p.m. And I will put out a notice when that time change has occurred. It's usually we will be starting in May to do that. But in any case, if you want to participate in the classes or have any interest in getting notifications of at least the free class, you can send me an email to taooflaw@gmail.com. Okay, TAOOFLAW at gmail.com, and I will add you to the notification list for the free classes. But you will also, by getting on that list, you will also get emails for subscription renewals. Because right now, the class subscriptions are the only money I've got coming in. And it's $80 a month for however many Thursdays are in that month, unless that Thursday happens to fall in the same week as a major holiday. If a Thursday falls within the week of a major holiday, there are no classes that Thursday. Otherwise, they're every Thursday from 7 to 9 or 8 to 10, depending upon which schedule we're on, winter or summer. And you will get notified of that. And $80 a month for what you can lose in one court battle, that's not a big deal. Okay? Especially when we're trying to teach you how to go to court and fight the case and win and make a record for appeal if you don't win at the trial level, et cetera, et cetera. But we go through everything. We go through analyzing statutes just like this to see how the government is reading and applying it versus what it actually says, and then we go into studying how to combat their misinterpretation and misapplication if and when we go to court on it. And I teach you all the proper procedures according to the Code of Criminal Procedure, at least as far as it goes in the state of Texas. But I also teach you how to understand statutes well enough that you can figure out how to use them in your own state. So even though the specific law isn't applicable to you if you're not in Texas, the methodology and the understanding is applicable everywhere. So all you have to do is take the process and procedure and the understanding from what you learn from me in my class and apply it according to the laws in your state and use it accordingly. And I've got people from all over that I've helped with that. I've got them in Utah, Oregon, Washington State, New York. Hell, I even helped a lady in London, England, when she got arrested for drug possession by a constable who arrested her for a prescription drug that was made out to her. And she won 7,500 British pounds off of him when she sued him.
Nice.
So not only did I help her beat her criminal case, I helped her win her lawsuit. And that's English law.
Yeah.
Okay? So the stuff that I do is proven to work, provided you implement it according to the proper procedures and the laws where you live. You do that, and you stand a very good chance of being victorious. You don't do that, then you get shot down. And you just take it as a learning opportunity about how you screwed up and how not to do it again. That's the same way the lawyers have to learn it. I went to court and I lost my case. Here's all the reasons I think I lost. So here's what I'm going to do so that situation doesn't come about and bite me in the ass the next time. That's how every lawyer learns. And you are basically, for all intents and purposes, learning to be your own lawyer. So you have to treat it the same way they do. It's a job, and a job requires effort and sacrifice. You will never get better and become great at your job until you give it effort and sacrifice. Right. So yes, there's a lot involved in doing it, but you just have to decide you want to and then get it done.
Well, send me email me all your links and stuff so I can throw them in the videos, and then that way they'll have all the links in the videos so they can see that. And y'all should start subscribing to his course, that 80-month buck course, and just take a few months and really expand your knowledge. It would do so. That's what everybody needs to be doing. And that's what I'm always doing, and that's why I have people like Eddie on, because he's always correcting me and and chewing me out when I do something wrong. But that's why we got to have Eddie around, man. He's the one that has been doing tons and tons of research. You have no idea how much effort and time he's put in on this. I remember going back to what was the underground bookstore, Brave New World or something, and
Brave
the
New Books.
Brave New Books, yeah, down in Austin, taking the courses down there way 10 years ago. And so
Longer
that's,
than that. I
oh
was
yeah,
doing those courses starting in 2010.
I think I was down there in 13. And that's when I was really, or
Yeah,
13 or
that's
14.
12 years ago.
Yeah. Well, and then after after getting my window smashed out by that Addison cop, you're like, boy, I told you.
I did. I had to chew your butt on that one because you were doing everything I specifically taught you guys to never ever do.
It's a learning curve.
Yeah, it was almost a painful one.
Man, I tell you what though, that video got 3 million views. If you only knew the.
Yeah, but not for the right reasons.
Well, I know, but it was an awakening. I'll admit that wasn't, yeah, I didn't do everything perfect, but it was an awakening and it woke up a lot of people. I had one guy that he was listening to all the videos and stuff we were doing back then. And he's a truck driver. He actually took a case to court and won, set precedent for it's something to do with truckers and their lights and stuff. But
Yeah,
anyway,
George Gordon did that once.
that was cool. So people were listening and people were paying attention. And now in the era of Doge, this is everything that we're doing basically is just a forensic audit. And once you start looking at it that point of view, I mean, I turned in those public information requests yesterday, so I got that all turned in. And it's going to be interesting to see how they try to squirrel their ass around the law as written. So I think it's going to be quite interesting. But other than that, I know this is kind of going on for a little bit of time, and I want to thank you, Eddie, for coming on and sharing parts of the book. I want to have you on more often so people can really start to pay attention to the work that you have been doing, and I enjoy it. So it's just good for me. So
I
any part,
appreciate that.
oh,
And
good. I'm,
yeah,
I'm
and
glad you do.
now as far as the class subscription goes for the $80 a month, guys, I just want to let you know you can actually get a discount on that if you do a 6 month subscription all at once. There's a 10% discount off of the $80 per month, and if you do a year, there's a 15% discount off of the $80 per month. So, and you can go to logosradionetwork.com to see the subscription options and to purchase the subscription if you want to join. Otherwise, you can send me an email and I will send you back the link to that, and I will also add you to the list for notification for the free classes and for the renewals for the subscription classes. All right?
All right. Well, I appreciate you, Eddie, and I definitely will be talking to you again, maybe tomorrow or something, because I'm gonna have to jump off here and go do some shit here in a little bit. So,
All right.
but
Well, I gave you the links to download this so you can post it up. So you should have everything. Just give it about, given the length of this, I'd say give it at least 30 to 45 minutes and then check the folder and download it and you can get it posted.
all right. Well, I appreciate you, Eddie, and I definitely look forward to talking to you again.
Yes, sir. You too. You have a great day.
You too. Bye.
Bye bye.